Okay, good evening everyone, and welcome to the first week back of our online seminars. Tonight we are lucky enough to be joined by Richard Silver, Senior Partner of Silver Shemmings Ash, and the latest in his Hot Topics series. Tonight's hot topic for debate is letters of intent. As always, if you have any questions for Richard, if you can pop them into the chat box or the Q&A box in the tool panel in the bottom bar of the screen, and then Richard will endeavour to answer as many as possible at the end of his presentation. With regard to the presentation, we will have to reissue these slides as I inadvertently missed a couple of slides out, so therefore I will send these around when we send your CPD certificates to make sure you have the most up-to-date set. So without any further ado, Richard, over to you.
Thank you, Julie. Good evening, all. Today we're going to cover letters of intent. For those of you who and whilst working in various areas within the construction sector, I was an engineer, an agent, a buyer. I found myself best suited to quantity surveying. I eventually somehow managed to get myself to a position of chief surveyor, but I equally then moved into the management field, helping with certain projects, and eventually became a construction director. During my years within construction, we commenced many projects under letters of intent, and equally, whether wisely or not, I will leave you to choose, we issued many letters of intent to our subcontractor. And it is my view that letters of intent are possibly one of the most misused form of paperwork, and it is too often not fully understood what the ramifications are from the issue of a letter of intent. I think the starting point is there's a perception that a letter of intent has a definition, and that you can say, it's a letter of intent and therefore it means this. Unfortunately, that's not the case. And as we're going to identify, we can establish that a letter of intent, depending upon the terms, can have a number of different meanings. But for those of you who don't know, what is generally perceived to be a letter of intent? Now, construction projects are extremely onerous, and every project, even if you're building an exact same house as one down the road, it's going to be different if you do it a week later, a month later. Different factors will occur, and a consequence of that, we have lots of very detailed contracts put together to deal with a whole endless potential issues that may arise. We then have to have full sets of drawings, possibly a BOQ, a schedule of works, loads of paperwork. And all of that's got to be agreed by the parties, ideally before they start, so that a contract can be issued. But too often, for one reason or another, someone, normally the employer, requires the contractor to start on site in the execution of the works without the contract having been agreed, let alone signed. Now, with good sense, the main contractor says, well, I'm not going to start on site if I've got no paperwork whatsoever. So what is issued is a letter of intent, an intent to place the contract in the future. But it is the case that sometimes those contracts are not placed. So the general view is this is a letter that is issued before the execution of the contract, and it normally gives the other party confirmation of the intention, hopefully sometime in the future, to enter into contract, but that nevertheless, despite there being no contract in place, the other party is nevertheless to start works on site. Now, why have they done that? It may be the case because they haven't agreed the contract. They haven't agreed the scope of works. They haven't agreed the start and completion dates. They haven't agreed the tender price. There could be a load of factors as why the contract could be not yet placed, because something's yet to be agreed. There may be restrictions on what works can be carried out because planning permission hasn't been obtained, or approval processes haven't been obtained, or that certain areas of land haven't yet been purchased, or there's still tenants on, so they cannot be vacated. There's a whole plethora of reasons why the contract cannot be placed. But in my experience, there is quite often one, and that is simply time. You have to put together all the contract. You have to find all the contract documents you're needing to incorporate. You want all the drawings in, you want a BFQ, you want lots of other paperwork. We need to put it all in this big pack. We need to send it over to you. You've got to sign it, return it to us. Oh, we want you to start today. It's going to take weeks to do that. So we issue a letter of intent. Now, as far as those letters of intent, lots of people in my experience have one saved on their computer, or they've found one online, or they've been issued one in the past. Now, they have various different wording. They generally start along the lines that we confirm our intention to enter into contract with you at some time in the future. They then say that this letter of intent will, in the meantime, set down the parties' responsibilities. It may well have a cap in it, either a cap as to value to carry out the works up to 2 million. You might have a cap as to scope. Please carry out the initial enabling works. Or it could have a time. Please carry out the following works up until June the 1st. It quite often says within the letter of intent that if and when the contract is formed, it will have retrospective effect, and that all payments previously made will be deemed as paid under the contract once signed. But if the contract does not actually get executed, then a party may be entitled to quantum merit. It may say that either party can bring the letter of intent to an end at any time, and that there will be no entitlement to loss of profit or other heads of claim. And those are the sort of standard letters of intent we have. But the problem is quite often there is uncertainty in that letter of intent, and there may be even greater uncertainty caused as the works progressed. And what I've tried to do is to sort of break down the letters of intent into 3 types. Now, type 1, in theory, should be of a non-binding obligation. In other words, there is no contractual link, where it simply says to party A to party B, we intend at some time to place an order with you. They don't ask anybody to start on site. It's just saying that we do intend to place a contract hopefully in the future. But the problem is quite often that doesn't happen. And what actually happens is the letter of intent goes somewhere beyond that in actually requesting the party to start on site, despite there being no written contract. And that is type 2. We then have type 3, which is in fact a contract, just not the final contract, an intermediate contract, which has set down the parties' obligations as and up till the contract is being placed. Now, I keep mentioning there being no contract, and if you look into cases on letters of intent, you will quite often see the term simple contract. And that term is used in circumstances where one party has actually started works on site. Now, if they had no entitlement to payment, there would be no contractual obligations, there'd be no contract, nothing. And a party could get works carried out with no liability. Quite rightly, the courts have found that that is not what occurs. So if there is no contract, there is still what is called a simple contract with an obligation to pay a reasonable amount or quantum merit. So what we need to identify is what is the difference between a contract and this simple contract where there is simply an obligation to pay a reasonable amount. And the simplest way of dealing with that is, in order for there to be a contract, you need to understand what's been agreed. What is one party going to do, when, and for what? So we need to have certainty as to the terms. What is it that one party or either both parties have to do under this contract? And the consideration is, what is the actual actions they're going to do, which is normally one is going to carry out certain works and the other one is going to pay them. And then there's got to be an obligation to enter into a binding legal contract. Generally, that always occurs. The exception is where there is what is perceived as social arrangement, which is where you decide to carry out some building works for your brother-in-law. There may not be perceived to be an intention to create a legal contract because of the relationship of family. Some of you may be saying that would be the person I will charge the most, but we won't go there. Dealing with the first form of a letter of intent, as I identified, there has been no agreement as to what is to be paid. And therefore, it will be implied that a person shall be paid quantum meruit, a reasonable amount. Now, a reasonable amount may not be the amount the contracted tendered. Indeed, I've always been a cynic who says if you win a tender, it's because you've underpriced it. I would suggest to you, if you're going to enter into a contract or enter into some form of arrangement with an employer where you're going to be paid a reasonable amount for whatever work you undertake, that may be far better than any tender. I mean, it's not far away from cost plus. Provided you can show that the cost you've incurred was reasonable, then you're entitled to that plus a reasonable amount. Great position to start with. The next thing is, because we have no contract, no specific agreement in place, there can be no breach of contract. You can't breach something which doesn't exist. And therefore, there can be no completion date, no damages for non-completion. You can't have a completion date, a contractual obligation, if there is no contract. Similarly, and one of the big factors is if there is defective works, you simply don't get paid for them. It's abatement. What you don't necessarily have a liability for is the cost of rectification. That can be a huge benefit. So in some cases, working under this letter of intent type 1, where you've actually started work pursuant to it and upon the request of the employer, could put you in a very strong position as a contractor. The only difficulty faced is the choice the employer may decide that they don't want you to complete the job and can actually ask you to leave straight away. But other than that, it's actually pretty beneficial to the contractor. Type 2 is where the parties have entered into a contract. It's just not the final contract for the whole of the works. But what they've done is they've written down an agreement that sets down what terms are applicable to that agreement. One of the big issues will be is whether this type 2 letter of intent continues to be in place or whether it has been superseded by a final contract. And the ramifications, as I'm going to show in some case law in a moment, can be quite significant. The final type I've listed here is, in effect, the contract. You can enter into a contract by one party submitting, an invitation being issued, which says that you shall submit your tender based upon the JCT form of contract 1998, design and build, with a start date of and a completion date of, and everything's there. All the information is there, and all you need to do is to submit your tender figure. You submit your tender figure, and the other party sends a very detailed response saying, accepted. We've now got an offer and an acceptance. We have a contract. We do not need to sign all the contract documents. We have a contract. Now, if we send that in the form of a letter of intent, We're simply saying further to your tender, it is our intention to enter into contract with you. We will be forwarding in due course all the contract documents for your signature. But in the meantime, and as per your tender, please start work on Monday. So whilst it's saying it's an intention to enter into contract in the future, the reality is, upon its issue, the contract is already in place. So the question is in looking at those letters of intent, is to try and establish whether they are a simple contract or a contract or something else. And it's all going to depend upon the particular wording within the letter of intent. And it is going to be a subjective view. It won't be what the parties necessarily intended. It will be what I, as an adjudicator or another person as a judge, looking at the documents, in their view, think the letter of intent means. And it is my experience quite often what they determine is the case is completely different to what the parties thought. I've been doing this for far too long, and I have been involved in no end of disputes under letters of intent. And every time I go down to site and I try and advise people on letters of intent, they want to argue with me. They just don't accept what I say. They say, but we're on site. We've been doing week works for 6 months. They've been paying us. We must be in contract, surely. And quite often, it's quite clear that the parties have not reached agreement on the contract, and that one party is entitled to quantum merit, a reasonable amount. Yet, the contractor, in submitting their monthly interim applications, is not seeking money on the basis of quantum merit, and the employer is definitely not willing to pay quantum merit. So even though it is quite obvious that is what the party is entitled to and what the other party is obliged to pay, neither party is following that necessary process. But what we need to do is to look at the letter of intent objectively to see, has there been an agreement? Now, if we read that letter of intent and it sets down a number of major factors that have not been agreed, you can't have an agreement. You can't have an agreement if there is major factors still not agreed. Just doesn't make any sense. So what we need to do is to establish what has been agreed. Now, the most important starting point, as I've said before, is you have to have scope. What is it actually you're going to do? And I've been involved in no end of jobs where it is so uncertain we can't even work out what they're going to do. We need to see if there's any specific terms which are key and have not been agreed. For example, if one party says, I want to be paid 2 million, and the other party says, I don't agree, I don't think it's that much, again, it's unlikely to be a contract because there is a fundamental issue which clearly has not been agreed. The next factor is what terminology isn't necessarily going to dictate the conclusion. So one thing parties do is to put on the head of their letter, subject to contract. I know what the intention is this is subject to contract, so there is no contract at the moment because we're subject to the contract getting in place. In this case, RTS, that's exactly what had happened. A letter of intent had been issued and which said subject to contract. One of the parties, however, wanted the contract to be in place, and more particularly, they wanted to get it confirmed that the MF1 conditions applied. And that would only be the case if there was a contract, notwithstanding that the letter of intent said subject to contract. As the judge said, and I do like this, the moral of the story is to agree first and to start work later, which we know doesn't happen. They decided that notwithstanding it said subject to contract at the top of the letter of intent, there nevertheless was a contract in place and that contract did incorporate the MF1 form of contract. And what the courts did was to put themselves in the positions of the parties, looking at the letters of intent and the whole circumstances, and they concluding, notwithstanding that there was no final contract, there had nevertheless been a contract executed with the MF1 conditions in place. And they decided that it was not necessary for the eventual contract to have been signed. They also looked at the conduct of the parties and how there had been further agreement and other things that indicated that the main contract terms applied, because the way they were administering the project reflected that there was a contract in place. And what they said at the bottom there is that no reasonable businessman would have felt at the relevant date that there was no contract in place between the parties. In other words, everybody would have concluded that there was nothing left to be agreed. The next case is a slightly different situation, and this ended up in considerable litigation, and as I'm going to show, there was an appeal and the judgment was reversed. What I'm identifying by the fact that the judgment was reversed on appeal is that not even all the judges can come to the same conclusion as to what is the effect of the letter of intent, because it can be so difficult to determine whether or not a contract has been put in place. And I think it will be useful just to revert and to confirm what is a contract. So a contract is very simple. It is an offer and an acceptance. It is one party putting forward one form of a proposal and the other party accepting it. And I should point out, acceptance can take three forms. It can be in writing. So if the party sends out an offer in the form of an order and the other party signs it, there's acceptance, fairly clear. There can be oral acceptance. Do you agree? Yes. Provided you can prove the person said yes, there's acceptance. There's no difference that it's not in writing. There's been acceptance, just may have some difficulty proving it. The final one, and which happens all too often on construction projects, is that there has been acceptance by conduct. And that conduct might be them starting on site, or it might be the other party allowing the person to start on site. But what we need to see is that there has been an offer and that sometime thereafter there has been an acceptance. And between the issue of the offer and the acceptance, there has been no rejections or counteroffers, because the effect of a counteroffer is to turn down the previous offer. Now, in this case, AMEC was undertaking a very large car park project. And as part of those works, they sought to employ Arcadis to undertake the design. But they also intended to get into a much bigger agreement for them to undertake a lot more works. And as a consequence, because there was still no final agreement, a letter of intent was issued. Arcadis undertook the design work, and then there was believed to be some fundamental errors in that design. Now, why Arcadis denied any responsibility for those design problems, they further argue and went to court to say that they'd entered into a simple contract, a contract that was to sit before the final contract was placed, but this simple contract included a cap on their liability to the tune of 610k. And this offer had been an offer that had been put, so Arcadis argued, on the table by AMEC. It hadn't been signed or agreed, but they said by their conduct in carrying out the works and other factors, it had been accepted and it was therefore binding on their parties, and therefore Arcadis liability, and I think from memory, the original potential losses for this design error was in the millions, possibly 8 million, they were saying that their liability was capped at 610. One of the key reasons was they said there could be no final contract. AMEC said that there could be no such contract in place because there had intended to be some form of protocol agreement in place, and that had never happened. Now, Justice Coulson started off by saying that where a party has actually commenced and carried out certain works on site, it is implausible to argue that there is no contract, there is no form of agreement in place. There must be something. You must be entitled to pay something if you've done something at the request of the other party. But what he said was what had happened was that the AMEC's offer had never been accepted, that there was so many things that were uncertain that it could not be the case that Arcadis had accepted the offer, this intermediate contract, which limited their liability for negligence. And he said, you know, on that basis that you have no excuse or reliance can be placed on a limitation of liability clause. And although I haven't put it down in the notes, he was rather scathing of Arcadis, and it was his view that they had done everything they possibly could to avoid entering into an agreement, which now, in hindsight, they wanted to rely upon. So upon that basis, he found that Arcadis, if they were found to be negligent, would be liable for all the losses of AMEC and not limited to 610K. As I said, the liability could have been in to 8 million. So not liking the judgment, Arcadis went over to appeal, and the appeal overturned the decision. And they said, as far as they were concerned, notwithstanding that these letters of intent had been issued, that there had been an agreement. And it was their view that AMEC had submitted an offer, and that Arcadis, by its actions in undertaking those works, had accepted that offer, and therefore the terms of that offer applied, and Arcadis's liability was indeed limited to 610K. To say the least, Arcadis were relieved. I'm going to turn to another case, and I think this one is very pertinent. I've looked at the delegate list for today and am aware that we have listening in, hopefully, a number of consultants. Now, in this situation, we had an employer who was looking to employ a contractor. The contractor was Kia, and there was an opportunity to get a contract in place. But for various reasons, a letter of intent was initially issued, and then further letters of intent were issued, and no one really bothered, for whatever reason, to get the contract in place. Because, as is often the case, everybody assumed a contract was in the place. No one really understood what the letter of intent meant. So what happened was the consultants did not advise the employer ample forth of the need to get a contract in place, or indeed even the fact that a letter of intent was not a contract and they should go and get legal advice. They didn't give any advice on the issue of letters of intent or contract formation. So the works continued to be carried out under this letter of intent, but unfortunately the works finished very late. And they were late by reasons of Kia's failures, which did not entitle them to any extensions of time on the basis of what were the cause of the delays. But in view there was no contract, they didn't need any extensions of time because there was no completion date. So there was no date to be extended. And more particularly, there was no damages. And as a consequence, time and damages were at large. So therefore, when Ampleforth sought to agree the final account, they were unsuccessful in seeking to recover any liquidated damages from Kia. So they instead went after the consultants, Turner and Townsend. And what their position was you are my advisors. You ought to have advised me of the implications of being under a letter of intent and not a contract, and at the very least advised me to seek legal advice as to whether I would be better placed to get a contract in place. You didn't. You simply issued the letters of intent on behalf of me and allowed those works to continue and effectively to be completed under the letter of intent. And by reason of that failure, I can now not recover from Kia liquidated damages. They advanced a case that a consultant acting in due skill and care would have advised me, and had they advised me, I would have been able to get a contract in place with Kia. And much of the case turned on whether or not, had they been advised, could they have got a contract in place with Kia? And it was determined, yes, they had the commercial strength to ensure that Kia signed a contract, and thereby they would have been able to get those damages. So, but for the negligence of Turner and Townsend, Ampleforth would have recovered the damages from Kia. So therefore, they were instead able to recover all the liquidated damages from Turner and Townsend as damages for negligence. This case caused problems between whether or not there was a contract in place. Situation again was a letter of intent had been issued, but the parties had not signed the contract. The courts found that whilst the contract had never been signed, neither party had said that the signing of the contract was a precondition to its formation. And therefore, notwithstanding the contract had not been signed, the eventual contract was nevertheless in place. It wasn't a simple contract, it was the final contract. So what we've identified is the difficulty associated with letters of intent. And I repeat, I think the first problem is that the reason the letter of intent can be a whole multiplicity of factors. But quite often, the letter of intent as drafted and issued is not drafted in the correct form to reflect those problems. It may be the case that the only reason the letter of intent is being issued is because everything has been agreed, but we haven't got the contract signed. Now, what we've identified is that's not necessary. So a letter of intent could simply be, I confirm the receipt of your tender, we accept, and it's an intention to send to you the formal documents for your signature in due course. But the letter of intent doesn't always say that. What it actually says is something completely different. It may say a cap to time, money, scope, that certain things are not agreed, that we can bring the contractor to an end at any time. What it's thereby doing is saying quite clearly, the eventual contract is not in place. So if the eventual contract is not in place, the first question is what's happened to the contractor's tender? Well, the point is if it hasn't been accepted, then it doesn't apply. It's very likely that the tender and its rates included are not to be used. And quite often it will be the case that the contractor is to be entitled to quantum merit. Next thing is letter of intent. What are the underlying terms? Well, it quite often says it's our intention to enter into the JCT design and build version, whatever. But that contract has a set of contract particulars at the front. The contract particulars say BOQ is included, schedule, activity is included, or number of things. Which one do you want to choose? It has a date for start, date for finish. It has who's going to take out the insurance provisions. It has a whole load of things that you've agreed. But if you simply refer to the standard form and those provisions have not been completed, you can have an underlying contract that has not been finalised. There also may be terms that are in the letter of intent that are at odds with the contract. Not least that you may be saying that you're entitled to quantum merit, and the underlying contract which you intend to enter into says something quite differently. Next thing is, as I've mentioned, quite often there is some form of cap. There is a cap as to time, cap as to scope, cap as to money. And the question is, what happens when that cap has been exceeded? And in the case of Diamond Build, they unfortunately had gone and undertaken works beyond the financial cap in the letter of intent and upon the instructions of the employer, but nevertheless were not entitled to any payment beyond the cap. So if the letter of intent is the simple contract under which I am working, and it says you should be paid up to £1 million, that's all you're going to get paid to. You go beyond that, you're not entitled to payment, unless, of course, a further letter of intent is issued. Now, there is a potential way out. That is where a party, in fact, pays an amount beyond the million. So I issue a letter of intent to you to say, carry out the works up to £1 million. You do the works, you then carry out the works up to 1.1, and I pay you 1.1. By my actions, I have indicated to you that that cap in the letter of intent does no longer apply. It is a representation that I have made upon you and upon which you have relied, and therefore I will be stopped. I will be unable to rely upon that cap. But it's a dangerous game to play. So my advice to you is, if there's a cap in a letter of intent, do not go beyond it. The next thing is the letter of intent provides for you to carry out certain works. What happens if that changes? They want variations, they want differences, they want different things to go on. Does the letter of intent cover it? Can the contractor simply say, actually, don't really like this, I'm off? You know, you can imagine as an employer, you've got the job 30% complete and the contractor walks, major problem. You've got to pay them for what they've completed, and then you've got to find someone to complete it. And the person's going to come on site and is going, oh dear me, and whatever you thought it was going to cost to complete, you might as well add on 50%. Next thing, letter of intent. What's going to happen with insurance? These are just a few potential problems you can encounter when a letter of intent is issued. So what I've tried to do is to set down some practical tips. I should have put at the top, don't issue them, but that may not have been too helpful. But first thing is, understand whether or not you need it. Is there anything actually stopping you from placing the contract? And if there is, and you need to issue a letter of intent, be aware of the risk you're undertaking. As far as a contractor is concerned, be aware of the benefits that you have or may have, depending upon the wording of the letter of intent. Be aware that certain terms you might like to have relied upon in the contract may not apply. So be aware that the starting point is it's not the eventual contract. Now, as far as the letter of intent, number one thing is always identify what a party is actually to undertake. You know, carrying out the works up to 1 month, it's not really clear. What are they going to do in that month? Does that purely include their prelims, or are you actually wanting works to be carried out? What works? You know, set down what you're actually expecting them to do. If there is something to be agreed, set down what it is that needs to be agreed. And be aware, unless it is very important, the courts may determine that the contract has been entered into. So if you recognise that you're in contract, you might want to say there's a letter of intent. The only things that we need to agree to is whether you're going to start on Monday at 8 or Monday at 9, or something very minor. But the more the agreed items or the unagreed items are major, the more likely that a contract has not been in place. Put down what the letter of intent is meant to be, that it is an interim contract and it is to be in place unless or until the final contract is to be in place. And that once the final contract is in place, it's going to displace the letter of intent. Simple one, detail what the governing law is and what the VAT situation is. One for me, identify what the dispute resolution process is, because you're going to get into arguments potentially that this is not a construction contract and hence there is no right to adjudication. So to be safe within your letter of intent, say that the scheme for construction contracts for adjudication will apply. In the letter of intent, say who is going to authorise to give instructions. Quite often the employer will employ an architect, a CA, a project manager. If they're the people who are going to instruct the works as they proceed, put that down in the letter of intent. One I referred to before, quite often at the end of the letter, is that the formal contract shall have retrospective effect, and that in effect, any payments that have been made and all the works as undertaken will be deemed to have been executed pursuant to the contract. Now, we'll say one thing on that, is I have and am aware that people having signed the contract have then put themselves in a much worse position. They've actually signed a contract where they know at the time of signing the contract, they cannot complete. And they then become liable for damages because they know they can't do it. I've equally seen contracts put in place where it says that the employer will give the contractor possession on such and such a date. And by the time they issue the contract, it's known that they weren't. But that's what you signed up to. So do be careful. Make sure the letter of intent is actually issued by the issuer, or make sure you know you've entered into who you've entered into an agreement with. I had a case, must be 20 years ago. And what happened was an employer went out to tender, the contractor tendered and looked likely to be successful. But before the contract was in place, a letter of intent was issued. But the letter of intent wasn't issued by the employer who had gone out to tender. It was issued by a shell company who had no money. And they couldn't get the contract in place, so they carried out all the works on a monthly basis, knowing that the final monthly payment was at risk. And that's what exactly happened. They ended up not getting the final amount of money because the company who had placed the letter of intent didn't have any. One thing that often happens is the issue of extensions of time, because it may be the case you've got an obligation to issue a notice of extension of time as soon as it becomes reasonably apparent. But the contract's not in place at that time. It's not in place for 6 months down the line. But then the contract shall have retrospective effect, and it's like it's been in place from day one. So you signing that contract and then being under it, someone can then argue, but you've not issued your extended time notice when you should have done. You should have issued it 6 months ago. Set down in your letter of intent what is going to happen if the final contract is not ever agreed. What's the obligation with regards to completing the works? Either party bringing the contract to an end. How they're to be paid. All these things. Don't, as I've mentioned, use a letter of intent as a substitute for a contract. Get the contract in place. If you're going to get the letter of intent, make sure it has all the terms in it, properly set out, detailing what are the applicable terms. Ideally, get the letter of intent signed. Yes, by them starting on site, they may well have accepted it, but it becomes uncertain. But if they're already on site before you issue the letter of intent, starting on site can't be acceptance by conduct. Make sure the relationship is properly put down. And lastly, don't go beyond its terms. Do not exceed any caps. So what's the conclusion? In my experience, in the majority of times, it is in the benefit of the contractor to be working under a letter of intent. Under that letter of intent, the contractor is entitled to quantum merit. It is possible that they will not have a date for completion and hence will not have a liability for liquidated damages. They're entitled to a reasonable amount, and which would include the cost associated with prolongation. And it may be the case that if the works are defective, they'd have no liability for the cost of repair, but simply are not to be paid for the works they've undertaken. Their only risk is that they may not be allowed to complete the works, and there may be dispute as to what is a reasonable amount, but they are generally in a stronger position. As far as an employer is concerned, not only are they at greater risk as to the final price, defects, time, they're also under the risk that the contractor may not indeed complete the works on time. So it is my view, as an employer, you are far better placed to put a contract in place before the works start on site. The final warning is to those of you who are consultants. If you decide that what is necessary to be put in place is a letter of intent, make sure you advise the client what that means. Advise them of the risk, and then don't allow that letter of intent to simply remain in place. Look to get the contract in place. If you can't, record why you can't and make sure that it is outside of your control and that you're also advising of the ramifications. Hopefully that has helped. Julie, are there any questions?
Yes, there are indeed. Someone has asked, do you recommend the use of a minor works form for simply enabling works or a PCSA?
The answer to that is, I think both can be used. It is, if on some projects, you cannot determine the actual scope of the works because there's so many things you don't know. I've been involved in no end of contracts where the parties have entered into a contract when they knew at the outset there were going to be so many changes. So if you're going to work on a London Underground where you don't know where all the services are, or you're going to work in some old building where you don't know where everything is and the existing drawings may not work, then it's sensible to do some enabling work so you can actually work out what the existing structure is, where the existing services are. So yes, get a small enabling contract in place where you say just to carry out the following works, and that post the enabling works, we'll then enter into another contract for the final scope of works, the full scope of works.
Okay, that's great. That was the only question. So obviously you've done a fabulous job of explaining it, and everyone has picked up on the important points. As always, this will be available on the website as from tomorrow. If you want to review it again, we're recording all of our sessions. So if there are no more questions, it just remains to say thank you to Richard for going through a letter of intent with us tonight, and we hope to see you all again soon online. Take care, everybody.
Thank you.
Oh, so one more note. Thank you very much, everyone's saying so. Thank you, Richard.